All right, let's give this a shot, see if this works.
In sports, referees and umpires are in charge of determining what is and is not allowed in a game. Referees and umpires make sure both teams and coaches follow the rules and play fairly. If a player or coach isn't playing fairly or breaks a rule that was agreed upon, then the referee or umpire has the power to issue penalties and consequences. Much like these referees and umpires in the sports world, our country has judges who are in charge of making sure people are treated fairly. They can determine if citizens have broken a law and can issue consequences. However, they also have the power to determine if laws or acts themselves are unfair. We call the power a judge has, specifically a U.S. Supreme Court judge, to determine if a law or act is unfair, the power of judicial review.
Now, this doesn't just have to be Supreme Court judges. Any federal judge can use judicial review, except that it only applies for that area. That's jurisdiction. We'll get into that with the PowerPoint.
Specifically, the power of judicial review looks at a law or act and determines if it goes against what is written in the Constitution. Interestingly enough, the U.S. Constitution doesn't explicitly give the U.S. Supreme Court the power of judicial review.
So that would mean it's not enumerated. You can't read it in the Constitution.
The power of judicial review instead came from a court case, Marbury v. Madison.
And a law. We'll get there.
Imagine applying for a job, being interviewed, and then getting the job. Congratulations. But not so fast. Before starting the job, the company you applied to is purchased by another company, and the boss that hired you was fired, as was the Human Resource Department who is in charge of sending you your contract and hiring papers. Thus, you do not have any of your hiring paperwork, and the new company will not officially let you start working at the company. A very similar situation happened within the U.S. government back in 1800. Thomas Jefferson, a member of the Republican Party, won the election of 1800. As a result, the outgoing president, John Adams, rushed to appoint members of his own party to fill government posts created by Congress. Some of the members appointed to fill government posts were judges. In order to officially take the position of a judge-to-be had to be given official paperwork. It was the responsibility of the Secretary of State under John Adams, whose name was John Marshall.
Okay, pay attention to that John Marshall thing. We're going to see that in Marbury in a minute.
To finish and deliver the paperwork and give it to each of the newly appointed judges. Although Marshall signed and sealed all of the paperwork, there were judges-to-be that never got their paperwork. Marshall assumed that his successor as Secretary of State, James Madison, would finish the job. But when Jefferson became president, he told Madison not to deliver the outstanding paperwork because Jefferson didn't want members of the opposing political party to take office. One of those people that did not get their paperwork was judge-to-be William Marbury. Since Marbury didn't have the paperwork in hand, he could not officially take his post as a judge. Because he felt he was being treated unfairly, Marbury sued James Madison and asked the Supreme Court of the United States to issue a court order requiring that Madison deliver his papers.
So a court order is going to be a writ. We'll get to that in a minute. And he went right to the Supreme Court because at this point they had something called original jurisdiction.
In a strange turn of events, the Chief Justice of the Supreme Court who would rule on this case was none other than John Marshall, the former Secretary of State under John Adams who began issuing the official paperwork but never finished before he left office.
So the guy that forgot to deliver the paperwork gets to determine if the paperwork should get delivered.
Nevertheless, the U.S. Supreme Court had to answer three main questions. First, did Marbury have a right to the paperwork which he was supposed to have delivered to him?
Basically.
Second, were there laws of the United States that would allow the courts to grant Marbury his paperwork? Third, if there were laws, were those laws constitutional? The court answered the questions as follows. Marbury had been properly appointed according to the law, and therefore he had a right to the paperwork. Secondly, because Marbury had a legal right to that paperwork, the law must offer a solution. That solution came from the Judiciary Act of 1789.
That's where judicial...
Unfortunately, Chief Justice Marshall said that part of the Judiciary Act of 1789 was unconstitutional.
Notice the part of the act. We'll get to that.
Marbury had brought his case directly to the U.S. Supreme Court, which is called original jurisdiction. However, in cases of original jurisdiction, the U.S. Supreme Court can only hear specific types of cases according to the Constitution,
So they have
which
to
is
be listed.
always the supreme law of the land. Since the Judiciary Act of 1789 was trying to give the U.S. Supreme Court power it didn't have because it conflicted with the Constitution, that part of the Act was deemed unconstitutional. As a result of Marshall's decision, Marbury was denied his paperwork. What made this case so important was that for the first time the U.S. Supreme Court said that it had the power to review acts of Congress. In this case, the
Notice the Supreme Court said it had the ability to review acts. It's not in the Constitution. It's not written in the Constitution.
Judiciary Act of 1789. At the time, Marshall didn't go so far as to say that it was the only body that could interpret the Constitution, nor did he say how their rulings would be enforced. Nevertheless, this case set the foundation for the U.S. Supreme Court's most important power of judicial review and established the U.S. Supreme Court as a power equal to that of the President and Congress.
No less in review.
Marbury